first case to come before the court today is in Re KM. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time for rebuttal, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium and keep your voices up. Please do not use the names of children or minors or victims during your argument. You can refer to them by initials, like initials or terms like the child, generic terms. The judges have read your briefs and we're ready to proceed when you are. Would you like to reserve time for rebuttal?
Yes, please.
Okay, and how much time would you like?
5 minutes.
Very well. Then you may proceed when you are ready.
Thank you. Good morning. Attorney Andrea Burdell-Ware for Brittany Patton, the appellant in this matter. Judges, thank you for your time this morning for oral arguments. You've indicated that you've read the briefs, you've read the transcripts, so you're intimately familiar with this. This case actually boils down to the act of one judicial officer substituting her judgment for that of another judicial officer, despite not finding any error of law or misapplication of the facts to the law or vice versa. Simple substitution of one's judgment for another's is not a basis for the judge to have overturned the magistrate's decision. In fact, the judge's judgment specifically indicates that it was a close call. It was so close that the judge almost couldn't decide, if you will. However, the judge then proceeded to completely upend the magistrate's decision. It's contrary to law. Much like this court doesn't substitute its judgment for that of the trial magistrate. It doesn't. And why? Because it doesn't have the benefit of seeing the parties in action. It doesn't have the benefit of seeing Mom testify, her demeanor, the facial expressions. It doesn't have that benefit. It doesn't have the benefit of understanding the nuances that come from witnessing someone testify at trial.
Counsel, I understand your argument, but doesn't the trial court have to make its own independent review and judgment?
It certainly does, but it doesn't have to overturn it without any basis to overturn it. Just as this court is going to review this, it will not overturn something that could be viewed one way or another if there's ample evidence to support the judgment that was entered below. That is what's going on in this case. There was ample evidence to support the magistrate's decision, and frankly, the magistrate was in a better position to understand the nuances of the parties and their relationship, having witnessed the testimony. Reviewing the transcripts in this matter, I was not counsel at the trial level, so I lacked that initial benefit. So when I read the transcripts, I was like, wow, how do we get there? I then proceeded to read the decisions, the magistrate's decision, and then the judge's decision. Unlike the judge at the trial court level, though, I did have the benefit of meeting my client personally, of having interactions with her to understand what was actually going on. The trial transcripts revealed, really importantly, by my estimation, that Dan had to be reprimanded during his testimony for being aggressive with the attorney. Put that in context. These are kind of scary proceedings for most people. They're unnerving on some level for attorneys to come and present in front of their peers. It certainly wouldn't be an occasion for me to come and have an argument or to argue with one of you. Now, looking at the trial transcript, Dad in this case didn't have any problem starting to ask questions of Mom's counsel on the stand. Imagine how that translated in the courtroom. So coupled with his testimony about things like he took Mom's money for paying the medical bill, but didn't pay the medical bill. So those kind of things, they have a synergy, in my estimation, when you view them in total. To read it on paper is one thing, but to put them together and see what happens at the trial, the magistrate was just in a better position to appreciate how those things transpired. The judge in this case clearly said it was a close call. So why? Why without pointing to anything? Well, the judge who reviewed it decided mom's mental health was potentially more an issue. The judge, when she reviewed it, decided that dad living with someone was beneficial. The magistrate had the benefit of seeing these parties and understanding that mom's mental health didn't present an issue in the hearing. So there's no doctor's testimony that mom has a mental health problem. There's some random text messages taken out of context from what the transcript reveals. Mom provides a completely reasonable explanation for. And on paper, the judge decides, independently, without any witnessing of my client, that that's a basis to substitute her judgment for the magistrate's. It's inappropriate and should not have been done. It's substituting her judgment without a misapplication or error of law. And really, because the case is such a close call, those little things make all the difference in the world. Dad was witnessed during the hearing with the interaction with the other attorney being aggressive. Imagine for one moment what that looks like for mom. Mom repeatedly testified during the trial of the matter that she felt the need to record the exchanges for protection. It's in the transcript. The magistrate got to witness whether mom was being truthful or disingenuous. She testified. The magistrate didn't find her to be disingenuous. Her concern was real. The magistrate specifically questioned her further. Sometimes it's hard to articulate those little nuances, but those are the things you get a feel for when you witness people testify. The magistrate had plenty of questions. The magistrate was able to witness these people testify, listen to the questions firsthand, and then pursue anything that maybe needed a little more clarification. For instance, Mom, tell me about these text messages. So that the magistrate, the trial magistrate, had a benefit, again, that was not reflected on a paper transcript. And the magistrate's decision should ultimately have been upheld. There was no basis in the judge's decision to change it. Lastly, and maybe most importantly, the parties testified what they wanted for custody. There is testimony, very specific testimony, and the magistrate cites to who wants one. The magistrate says, Dad wants equal time. The magistrate recognized that Dad wanted equal time and wanted to participate in the upbringing and life of the child. Dad testified to that. The magistrate honored his requests. Mom testified that she wanted custody, that she would, in fact, share custody of the child in the sense of equal parenting time, consider Dad's opinions. The magistrate considered that. So the magistrate's decision, in fact, took into account all of the testimony, not just Mom's, not just Dad's, but actually balanced those competing interests in a manner that reflected the child's best interest by respecting Mom's wishes and Dad's wishes with his decision in this case. The magistrate talked about mother's mental health concerns that were brought up at the trial, and the magistrate specifically found they're not as substantial as those pertaining to the father's ability to make consistently reasonable parenting decisions and to facilitate a positive relationship between child and mother. This goes back to the interactions the magistrate sees at the trial, the interactions that father has with mother's counsel.
So do you think that the trial judge calling the isolated incident of aggression was just the wrong fact then? Because you're talking about things from the magistrate's decision, things that occurred during the hearing, the magistrate.
No, it's a really good question. Thank you. No, I don't. And in fact, this was in the brief. It fails to incorporate the other thing that happened. So you get twofold what's going on here. The magistrate says, rather the judge says, it's a one-off. It's a one-off. It only happened one time. But coupled with what happens during the hearing, it's not a one-off. It takes a lot of nerve to come into a court and disrespect an attorney. It does. It takes a lot of nerve for that. And then to argue with the magistrate, to continue to interact with the magistrate instead of going, whoa, I don't know what I was thinking, just to continue that pattern. Now, to put that into perspective of this case, this is what mom deals with all the time. I think the judge's decision also didn't really reflect the fact that mom was not under a court order to provide dad with equal time for this child. But a good parent seemingly would if they could make it work. And she did. You know, the court, as we all know, it's axiomatic. It speaks through its journals. There's no order that says, Mom, you will in fact share this child equally with Dad, but Mom in fact does that. And I think the other interesting that happens is revealed in the trial testimony. Mom makes a lot less money than Dad. So,
Counsel, I do want to let you know you're moving into the double time.
thank you. She makes a lot less money than Dad. She files for child support. Within just several weeks of filing for child support, there's suddenly an action for custody. Dad does offer an alternate explanation, but frankly, it's disingenuous, and there's no basis to believe that. Thank you.
Thank you.
Thank you, Your Honor. May it please the court. I'm Danielle Kulik, and I represent the appellee, Jordan Moser. So this case is, for me, it does not have an abuse of discretion element in it. As we've stated, the parties were fairly equal. We don't have drug addicts, we don't have abuse, we don't have anything here. We have a great mom and a great dad. And they didn't want to do shared parenting. As we can see, these parties can't really come to much agreements other than, yes, we're going to do equal parenting time. And I love that. That's why there wasn't temporary orders. They had equal parenting time. They were happy with that. What they couldn't agree on is where this child will go to school and how they're going to decide other major medical decisions, which is why custody gets allocated to one party when the parties cannot agree on this issue. Jordan Moser was the predominant caretaker of this child. That's not contested. He raised this child. The child lived in his home, which he owned before the child's birth, which he still owned at the time of the hearing, which he was going to reside in forever. Mother didn't have a home. Mother moved out from father's home with child, and mother during the trial was planning on moving again. So the child really had no stability in mother's home. So what we're looking at here.
Wasn't she forced to move out though? If you get break up with somebody and there's no marriage, like what else would she do?
I mean, she certainly can move out, but she didn't have a stable home. So it'd be one thing to move out and she bought a home and she was going to reside there and she looked into the school district and she made a conscious decision. Here she moved in with her father and then she was going to move to Medina, which had really no reason, no rhyme. And when I questioned her about it, about what the trial, why are you picking Medina? What's the school like there? She hadn't actually looked. This move to Medina wasn't in her kid's best interest. She even brought her child back to my client's Wadsworth for trick-or-treating, noting on the stand that she said, well, this is where my child's used to trick-or-treating. She brings the child back to Wadsworth to go babysitting with Becky, their babysitter who lives about 5 minutes from my client's home. So her move, which she is completely allowed to do, just wasn't in the child's best interest, and moving the child with her and knowing she was going to move again was just not in the child's best interest. My client provided stability. It's not an abuse of discretion or arbitrary or unconscionable for the child to remain with my client. What I think the appellant is doing is misconstruing the case law and laws on how to look at this. We're looking at whether this court is looking at the judge's decision for an abuse of discretion or whether the judge has to defer to its magistrate. And that part is wrong. The judge conducts an independent review. The judge does not have to defer to its magistrate. The case I cited, Enri LT, states clearly that is the wrong construction of law. The judge and the magistrate are different people. The magistrate, I think they called it a subordinate. The magistrate I'm not trying to minimize their role, but their role is lesser to the judge, and that's why we have that the judge conducts their own independent de novo review. To say that a judge must defer to their magistrate unless something would be incorrect. And herein, again, this is not a credibility case. At no point did mother and father's testimony really differ. There wasn't an issue where we could say mother said this happened, father said this happened, and magistrate judged the credibility. This is not a credibility case. And stating that a judge can not substitute their judgment for the magistrate, again, if we put that into case law here, if this court says that's what the judge has to do, that would be completely wrong. When appellant here said that my client was aggressive, and I feel like she was saying to his counsel, that didn't happen. I was present. If that's what she read in the transcripts, that's what she read in the transcripts, and this court has those same transcripts. But there was no aggressive behavior from my client. There's nothing like that that I observed in person, or that the magistrate observed in person, or that the magistrate found in their findings. So that's we're kind of missing the point of this case by looking over there. I feel that's a misdirection. What we need to look at is the facts of this case, my client's stability, what he could provide for this child, and when they're arguing that mom makes so much less money than dad, again, I put it in there, I did some math, it's not my favorite, but mom took actually a job making less money. If she had stayed at her other job, she would have been making the same amount as dad.
Excuse me, counsel, is that when mom moved from working on third shift to second shift?
Yes.
Okay, so she took a job working second shift, which would allow her more time with the children?
Yes.
Because isn't there, am I gonna find things in the record that she was criticized for working third shift, so she did not get to spend time with the kids?
I wouldn't say we was criticized, it was discussed that she didn't spend time with her child while she was working that shift. And we have no problem stating that she changed shift and now we have equal parenting time. Again, this isn't a parenting time case. We're
Okay,
very
but
happy.
I was just wanting to understand your comment there about how she took a job for less money.
Yes, I guess I should say it's the same job, just a different shift for less money. But her income is essentially equal to dad's. Even at her current position with that shift, I believe it was in my brief, I think dad's at 48 and I believe she was at 34. So we're not talking a father who makes $100,000 and a mother that makes minimum wage. They're fairly equal.
I'm just gonna ask you, because I didn't understand when I was reading the briefs. When she was the one that was awarded sole custody, his obligation was much lower than when it was reversed, even though she makes less money. So how did that turn out that way?
And that, I actually did not notice if the obligations were different. It would be just based on the guidelines, and I do know the final award, mother did get a 50% deviation. It's possible that the deviation number was different.
I'd have to look at that closely.
Yeah, I'd have to double check that, but again, whether or not to deviate child support and by how much is up to the court. And certainly we can look at the deviation numbers. I believe in this case, my client didn't even want to receive support from mom. I believe he testified that they're both gonna equally pay into account and pay the caregiver, the daycare. So for me, that was really the only issue here, is certainly, if we want to change the child support, we could have done that at mediation, we could do that at any time. The parties can agree to that later, but it wasn't still an abuse of discretion to change a deviation amount. And I put that in my brief. Mother wants 100% deviation or more deviation. It's just not in the record as to why more of a deviation would be required. If the court believes that the deviation was too much, too little, certainly, that could be addressed. But the main issue for my client is custody, and he wants the child to go to school with the child's sibling. He wants the child to go to school within the school building next to his house, and he wants to have some control over the decision-making process. So that is my main concern here today. If there are no other questions, thank you.
Very well, thank you. You may proceed on rebuttal, you have 4 minutes and 36 seconds.
Thank you, Judge. Counsel indicated that they couldn't come to many agreements. The trial transcript showed a very, very clear pattern. Parties get along, according to their testimony, until mom asks for child support. At that point, and forevermore, during the testimony, there is no ability to get along. They don't communicate well after that. Dad doesn't return mom's calls. Dad doesn't return, well, I should say texts. Mom likes to text according to the trial transcript. But after that happens, then they're not able to come to agreements. So it's a little bit inartful to say they couldn't come to many agreements. They did just fine for quite a period of time. I would indicate also that a big piece of this money thing is treating mom differently for making less money than dad. Dad makes $34.93 an hour. Mom makes $15.75 an hour. So when we get to the trial and they're testifying, and then we get to oral argument today, it tells me, well, mom moved. She had nowhere else to go. Well, let's see. She asked for child support. Dad didn't provide any child support. She filed for child support. She didn't get it because of the timing of filing for support and also filing for custody puts it on a stay. She then has to pay for attorney's fees to fight about who gets the child, all while making less than half of Dad's hourly wage. She then moves into the trial transcript shows the only place she could afford to stay without Dad in this new situation, and then they get back together and she gets a break and she's living with him, but then she's the one that's forced to move again when it doesn't work out. It doesn't do anything to Dad. Dad just kicked back in his chair. Hey, my house, you're out, and I'll keep the kid. Well, nobody wants to lose their child because they couldn't continue a relationship with the child's parent. It's really important that mom be treated equally despite the fact that she doesn't make equal money. She has every right to her child. As it relates to the child staying in a community, the child at this point is like 2 years old. To be crass, they're pretty portable. You pick them up. They don't go to the neighbors by themselves. They don't develop independent friendships. They go where mom and dad go. So when mom goes to this place, child goes to this place. When mom says you interact with this other 2-year-old, you interact with that one. When dad says you do it here. I mean, there's no community really for a 2-year-old child other than what is created for the parents and where they choose to live. As far as schooling, you have a couple years until the child's even of school age. Until then, it's where you're going to pay for a child to go to preschool, or whether you're even going to put a child in preschool. It's not about community. It's not about the child has to be 5 minutes from the school. It doesn't matter. The child is 2. Who cares if the child's 2 minutes from dad's school or 20 minutes from dad's school? If, in fact, that is something that needs to be determined, it probably comes at a later time, like when the child is anywhere near school age. There was a lot of testimony in the case about dad was primary. Well, my review of the trial transcript didn't actually show that dad was primary. And in fact, this was addressed in the brief. Mom did much of the parenting time. Nobody parents, so to speak, during third shift. Third shift is when the world is sleeping. Child, dad, and everyone except mom. Mom is working. So then the trial transcript also showed that, it's 9 a.m. and mom's texting she's going to have to go to bed. So how many hours of sleep did mom get before she got up, ensured that the child was going to be taken where she needed to be, come home, rest a little bit more, go pick the child back up, get some evening parenting time before you do it all again? And I would add that, mind you, that this is all during COVID. These are all really weird times for everyone. This parenting stuff happens during COVID. So daycare providing is odd. Schedules are odd. Mom finally does get a job working a shift that allows her to parent in the way that she would want to. And by the way, she has no choice but to get a different shift because she doesn't live with dad.
You're going to have to wrap up.
Thank you. When mom stops living with dad, she has to get a new shift. She has to take a lower wage. Thank you.
Just one point before you leave. You said this all happened during COVID. Was the child born during when was the child born? 2 years ago?
Child gave birth?
4/17/19.
Oh, yeah. Really should. Okay. All right. Thank you,
2019.
counsel.
Thank
That
you.
would be all. Thanks. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. You will both receive a copy of that decision from the clerk of courts on the day that they'll mail you a copy on the day that it's released. And the opinions will also be posted on the Ohio Supreme Court website. Thank you again for your presentation.
Thank you, judges.